Hello everyone, welcome to the channel Contract Simplified. I am Advocate Kritika here today with the new video all about the impact of privacy regulations on contract formation in the data-driven economy. Here we will be studying about data processing agreements, that is DPS or clauses, confidentiality clauses, data breach clause, consent and legal biases, cross-border and data transfers, audit and regulatory compliances, data subject rights of individuals. So let's get started. In today's data driven world, protecting user privacy is paramount. Contracts play a crucial role in ensuring compliance with evolving privacy laws and establishing clear expectations for how personal law is handled. This article explores the intricate relationship between contracts and privacy laws, highlighting how they work together to safeguard user information. Let's start with data processing agreements, DPAs, or clauses. There are specific type of contracts required under laws like the General Data Protection Regulation GDPR. They define the roles and responsibility of parties, that is data collectors and data processors, regarding personal data handling. Data protection clauses can outline how data will be collected, used, shared, and protected. Contracts often detail how security measures that must be taken in place to protect personal data. In India, Section 8 of the Digital Personal Data Protection Act 2023 does not clearly prescribe what each processing contract shall contain. It states only that there must be a valid contract. Further breach in observing the obligation of data fiduciary to take reasonable security safeguards prevent personal data breach under subsection 5 of Section 8. Penalty may extend to 200 to 250 crore rupees. Breach in observing the obligation to give the board or affected data principal notice of a personal data breach under subsection 6 of section 8. Penalty may extend up to 200 crore rupees. Confidentiality clauses. These ensure that the personal data is not disclosed under any circumstances to authorized parties. They ensure that the personal data is not disclosed to unauthorized parties. For example, confidentiality clauses may state that the employees with access to personal data must sign a non disclosure agreement NDA to prevent unauthorized sharing of information. Additionally, while sharing personal data, including confidential information, CI with third parties, contracts should include specific provisions. These provisions mandate that third parties maintain the same level of confidentiality and data protection as the original parties. They must also agree to use the information solely for the purpose outlined in the contract and implement adequate security measures to protect the data. Next, we have data breach clause. Contracts may specify the procedures and timelines to notify affected parties and relevant authorities in case of data breach. Contracts may specify which party is liable in case of non-compliance when privacy laws or data breaches. These clauses can require one party to compensate other for losses arising from privacy law violations or breach of data protection obligation. Consent and legal basis. Privacy law require that the personal data to be processed based on consent or other legal basis. Contracts must reflect these requirements, ensuring the data subject rights are respected. Cross-border data transfers. Many privacy laws have provisions governing the international transfer of personal data. Contracts must include appropriate safeguards such as standard contractual clauses, SCCs, or binding corporate rules, BCRs, to ensure compliance. Audit and regulatory compliance. To ensure compliance with privacy laws, contract might not grant one party the right to audit the other's data processing activities. Contracts may stipulate cooperation with regulatory bodies and compliance with the requirements. Privacy laws like GDPR, that is the General Data Protection Regulation, and CCPA, California Consumer Privacy Act, set the ground rules for how business can handle personal data. Contracts entered into by business that collect such data need to comply with these regulations. Parties must continuously monitor and update their practices to remain compliant, and contracts should reflect this ongoing obligation. Data subject right of individuals. Privacy laws often grant individuals right over their data, such as access, correction, and deletion. Contracts can't override these rights. For example, a contract cannot deny someone the right to access their information if mandated by law. Both privacy laws and contract best practices are constantly evolving. Business need to stay updated on both to ensure their agreements are legally sound and respect user privacy. The relationship between contracts and privacy laws is foundational in ensuring that personal data is handled legally and ethically. Contracts serve as a mechanism through which compliance with privacy laws is operationalized and enforced. They ensure that all parties involved in data processing understand and adhere to their legal obligation, thereby protecting the rights and privacy of data subjects. In short, privacy laws set the boundaries and contracts help the business to operate with them. By understanding this relationship, business can create contracts that are both legally compliant and respectful of user privacy. If you have any questions or require any additional information, please feel free to reach out to us via WhatsApp at 9945893415. And here in the description, you can find the link for subscription of the newsletter so that it will be directly in your email box as well as in your WhatsApp. So this is all about the laws that we are studied, that is the privacy laws and their impact in the contractual world. For more information like this about the contract and contract lifecycle management, please do not forget to like, share, and subscribe to the channel Contract Simplified.